When I ran for state's attorney for Baltimore City, I promised three things. I promised to focus intently on the prosecution of violent criminals, to operate the office in a manner that addressed crime holistically, and to hold everyone within my jurisdiction, no matter your race, your religion, your gender, your socioeconomic status, or your occupation, equally and fairly under the law. 23 months into my administration, we have proven that we will do just that. I stand before you today after convening and consulting prosecutors around the country alongside of the Association of Prosecuting Attorneys to announce sweeping police accountability reform proposals with the sole goal of opening a dialogue about the role that prosecutors, police, and community members play when citizens are seriously injured or killed during interactions with police departments. Having learned the hard way through firsthand experience, when allegations of police misconduct arise, prosecutors are seen too often as protective of police and unlikely to prosecute cases of wrongdoing. Despite taking an oath to administer justice fairly and equally to everyone, regardless of their race and their sex and their occupation, exacerbating factors such as fear of straining the police-prosecutor relationship that other casework depends upon can make looking the other way on police misconduct seem like the lesser of two evils. All too often in this country, we've seen it time and time again. 4 months into my term, and impassioned by the explicit oath that I was sworn to uphold as the chief prosecutor for Baltimore City, I broke a long-standing protective norm in the pursuit of justice for a 25-year-old black man against a few members of the Baltimore Police Department and learned hard, valuable, and challenging lessons along the way. The challenges that I was presented with throughout the course of 14 months served as a daily testament to police and prosecutors having both inherited a legacy of failed policies, laws, and practices in the criminal justice system, which leaves us to ask not whether reform is needed, but rather how it can be most fully achieved. The following policy proposals are designed to move us beyond historically ineffective approaches to police misconduct and address the investigation, the prosecution, and the administrative hearing phases of police misconduct allegations. My first proposal involves replacing the typical police investigative team with one that includes impartial investigative representation from the police department, the prosecutor's office, state police, and the investigator and the civilian review board. The collaborative approach will improve transparency, remove additional pressures of police investigating fellow officers, and eliminate inherent bias and public skepticism during the earliest and most critical stages of the investigatory phase. My second proposal is to grant police powers to the state's attorney's office in Baltimore City. Police powers to our investigators, much like they do in Garrett, Dorchester, Talbot counties, and other jurisdictions nationwide. Such powers include the ability to issue warrants, make arrests, and carry firearms. These reforms will allow state's attorneys' office investigators to participate as full partners in misconduct allegations. We need that. My third proposal, I will ask the Department of Justice for the development of a memorandum of understanding between local prosecutors and the U.S. Attorney's Office, allowing federal prosecutors to review cases of misconduct at the request of the local prosecutor following a no-charge decision, giving them the authority to bring charges under state law in state court by way of cross-designation. We already do it. This approach would preserve local leadership and accountability, which is so badly needed, while introducing third-party review in order to buttress the public trust in the process. A prosecutor must be capable of acting independently to hold officers accountable who break the law, all while balancing the necessity of transparent oversight and the need for local leadership accountability. Fourthly, I'm calling on state legislators to enact state laws that allow prosecutors and judges the ability to reject defendants' preference for a bench trial, whereby a diversely composed jury, as we've all seen, helps maintain public trust and imparts credibility on the outcome of the case, especially as it relates to police misconduct. The jury trial as an institution that reflects our democratic values of representation and deliberative decision-making.